Hello and welcome to Win Without Law School. I'm Arizona lawyer Julie LaBenz. Thank you for joining me today. Today we're going to talk about discovery in the context of a post-decree or post-order modification or enforcement case. So we've talked about disclosure, and now this is discovery, which is a bit different. And so let's start there by talking about what is discovery and what's the difference between discovery and disclosure. So discovery are legal tools that you can use to obtain answers, information, and documents relevant to your case. Disclosure are documents and information relevant to your case that you are required by law to share with the opposing party under Rule 49. Discovery is optional. You don't have to utilize it, but it's additional tools that are available to you to seek additional answers, information, and documents that are beyond Rule 49 that you believe would, be helpful and relevant to your case. What are the discovery tools that are available? Well, there's a subpoena, there's interrogatories, which are a list of questions. And interrogatories can be uniform, which are a set list of questions that have been created for family law, or non-uniform, where you create your own questions for the other side to answer. You can utilize a request for production, which asks the other side to produce certain documents, allow you to inspect property, things like that. Request for admissions, this is where you're asking the other side to admit or deny a certain fact or statement. So a yes or no, or a true or false, and then explain if they're saying that's false or if they're denying it, to explain their basis. A deposition. Deposition is under oath testimony that happens outside of court. So it usually happens in a conference room, in an office. There's usually a court reporter there, but that's not required. What is required is that the conversation be recorded. The person who's answering the questions is put under oath, and then testimony is given. And that testimony can be used in the form of the written deposition transcript at a future trial or hearing. Evaluations, you can seek a mental, physical, or vocational, a job-based evaluation. What are the grounds to object to a discovery request? Well, some grounds relate to the scope of the request, and there's limits to the scope. So in general, parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case. Written discovery to a party may not request information that party is required to disclose under Rule 49. On its own, or on motion or on its own, the court must limit the frequency or extent of discovery otherwise allowed by these rules if it determines that the discovery sought is unreasonably cumulative or duplicative, or it can be obtained from another source that is more convenient, less burdensome, or less expensive, seeks information that the party has had ample opportunity to obtain, or is outside the scope permitted by 51B1A, which is this right here, the scope. So there's various objections that you can make. And so what we're looking at is the discovery request relevant to the case? In particular, considering the importance of the issues at stake, the amount in controversy, the party's relative access to relevant information, the party's resources, the importance of the discovery and resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefit. So you could make potential objections based on it's not relevant, it's unduly burdensome or expensive, it's cumulative or duplicative, it's privileged information. those are some objections you could make. However, keep in mind that if you're going to object, meaning you're refusing to answer a discovery question, or either a question or a demand to produce documents, or a demand to show up for a deposition, or to produce records under a subpoena. If you're going to object, then you're going to need to have grounds, and you're going to need to be ready to justify those grounds. So there's a question about when you object. Well, you have a response deadline to respond. So you can object at the time your response is due, because you may answer some of the questions and then object to one or two of the questions. So your objection could be lodged at the time you do your response. Also, you can make a motion to the court to limit the extent of the discovery. So you could also receive the request, object to it, and you could potentially get the court involved to get a ruling on that. But overall, your objection should happen before the deadline to respond runs. If you're being asked to produce electronically stored information, then you can object if you can show that the information is not reasonably accessible because of undue burden or expense. There's some other parts to that rule, so definitely look at that if that's an issue in your case. What about a claim of privilege or work product? You can object on a claim that information or a document is privileged or subject to protection as work product. Work product is generally what an attorney produces. So if you worked with an attorney and they gave you some notes or something like that, that would be work product. The party must promptly identify in writing the information, document, or electronically stored information withheld, and describe the nature of that information, document, or electronically stored information in a manner that, without revealing the information, that it is privileged or protected in order to enable the other parties to assess the claim. So again, if you're going to object under any of these objections, you need to justify your objection. Let's say you responded to a discovery request, but then you realize that you need to supplement your response because new information arose, or you need to make a correction. You can do that under this rule. In fact, you must supplement or correct a response if you learn that the response was or has become materially incomplete or incorrect, and if the additional or corrective information has not otherwise been disclosed already. And you're supposed to do that within 30 days of learning that the response is materially incomplete or incorrect. Subpoena. So what we're going to get into now is the types of discovery requests you can make. And one of them is a subpoena. A subpoena is a court order to produce documents or to appear in court to testify. So keep in mind, there's two requests that can be made under a subpoena. Number one, to produce documents. So that's usually a subpoena to a bank or to a credit card company to produce historical records. Or you can subpoena a person to appear to testify in court. So you can subpoena records from an institution or a corporation or something like that. You can subpoena a witness to testify. Some examples of records that can be obtained via subpoena: bank records, credit card records, investment, brokerage account records, counseling records. So really any type of records from an institution that are relevant to your case, you can potentially subpoena those. Now I'm going to go over Maricopa County's standard subpoena form, and here's some things to keep in mind when you're filling that form out. Make sure you identify the appropriate person or department to address the subpoena to. Make sure you have the correct address. If you're dealing with a corporation, determine their address for purposes of receiving service of a subpoena. Some big corporations like credit card companies, they have a specific subpoena department with a separate address to mail the subpoena to. So make sure you have the correct address for where you want to send the subpoena. Use very clear and precise language in describing the records you are requesting to be produced pursuant to the subpoena, and clearly state the deadline to produce the records. You need to allow at least 14 days, and also clearly state how you would like the records to be produced. Are you asking they send them to you via email? If so, you need to provide your email address. Are you asking that the documents be produced by mail? If so, you need to produce your mailing address or provide your mailing address. And then keep in mind the person or the business that is producing the records pursuant to the subpoena, they can charge a fee or a cost to produce the records. So don't be surprised if you get a bill from them for the time or materials they spent in fulfilling the subpoena. So just keep that in mind. There could be an additional cost. Also, when you file the subpoena with the court to get it issued, there'll be a subpoena issuance fee as well. Here's what Maricopa County's standard form looks like for the subpoena. So you'll fill out your caption, your case number, and then this is where you need very specific information about who the subpoena is going to and the address. If you're looking to subpoena somebody to appear for trial, here in number 1, you would check this box and fill it out. Oh, went too far. If you're subpoenaing someone to take their deposition, that would be number 2. And then here's a subpoena ducis tecum. That is a subpoena for records. And so if you're wanting to subpoena records, you would check box 3, list the documents you're requesting. You can attach additional page with the description, and then indicate how they're supposed to get the documents to you. And I would tailor this very much, because you're likely going to put something in here about send it to me via email at my email address and provide that, or mail them to me at my mailing address and provide that information. The court clerk will do the date and sign here, so you don't need to fill out the bottom part. Here's information about the subpoena for the person receiving the subpoena to know how to object and what's expected of them. And then a final signature part for the court clerk. Here's the certificate of service. So let's look at this next slide, serving a subpoena. Actually, I'm going to go back for a second. We'll get into service in a second. So you've completed the subpoena form. Next, you're going to take it to the court, have the court issue the subpoena, pay the issuance fee. At that point, you need to mail a copy of the subpoena to the opposing party, because they're entitled of a copy of the document that you file with the court. Now we have a question about depositions, and we're going to get to depositions later on in this presentation. So we'll talk about that then. So the bottom line is, if you get a subpoena issued by the court, you need to mail a copy of that subpoena to the opposing party or their attorney. Then you need to serve the subpoena on the person you're demanding appear in court to testify, or upon the business or institution that you're looking to produce records. So under Rule 52D, anybody who's not a party to the case and who's at least 18 years old can serve a subpoena within the state of Arizona. And then you need to file proof of service with the court. Now, for a lot of these subpoenas, you're not going to be able to serve it in state. Like if you're serving a subpoena on a credit card company, for example, you're not going to go and hand deliver it to them because they're likely out of state somewhere. So that's where I would utilize some of the other service options, for example, service by certified mail. So number 1, you're going to submit the completed subpoena form to the court clerk, pay the subpoena issuance fee, mail a copy of the subpoena to the opposing party or their attorney, serve the subpoena, and then file proof of service with the court. For additional service options, you've got the acceptance of service. You would file the completed acceptance of service with the court. Certified mail restricted delivery, you would file the affidavit of signature confirmation with the signed green card and mailing receipt with the court. This is also known as an affidavit of service by certified mail. Or you could hire a process server, and then you or the process server would file an affidavit of service, also known as a proof of service. Let's look at the affidavit of service for subpoena. This is the standard form for Maricopa County. So this is going to work if you're serving in state and you know who it's going to, and you have somebody other than yourself who's not a party to the case, who's over 18, who can serve it. This would be the form to use. If you want to work with the person you're serving the subpoena on for them to accept service of it, you can use the acceptance of service form. You're going to need to tailor this to work. You're going to need to list down here the name of the subpoena, give some information about it. And then you'll want to cross out paragraphs 2, 3, and 4, because those don't apply to service of a subpoena. Sign here. The person accepting service of the subpoena would sign here before a notary, and then this document would get filed with the court. If you're going to serve by certified mail, you can use Maricopa's County Standard Form for that. Fill it out. The subpoena is not listed in these standard boxes, so you'll need to list it down here. And then you would sign down here, attach a copy of the signed green card and your mailing receipt, and then file that document with the court, and that would be proof of service by certified mail. Okay, so that's a subpoena. Now let's talk about another type of discovery tool, which are uniform and non-uniform interrogatories. So this is under Rule 60, and interrogatories are written questions from one party to the other in which they're answered under oath. They're answered in writing and under oath. There's a maximum of 40 written interrogatories that you're limited to, and a uniform interrogatory and its subparts count as one, but any subpart to a non-uniform interrogatory is considered a separate interrogatory. So if you're served with over 40 interrogatories, this could be an additional objection you could make, saying, objection over the 40 written interrogatory limit. And then there are uniform interrogatories that have been created. You can find those in the Arizona Rules of Family Law Procedure, Rule 97, Form 7. And I have that form here, at least part of it, and I'll show you what it looks like. To serve non-uniform interrogatories, you're going to serve a copy on every party, which is going to be sending them a copy by mail. Same thing for the uniform interrogatories. You don't file them with the court. And let's look back at this Part B. So with the uniform interrogatories, there's a lot of them, and not everyone is going to apply in every case. So you can serve the standard one with all the questions, but if you do that, you should include on top of it a document called Notice of Service of Uniform Interrogatories. And in there, list out the exact numbers you're wanting the other side to respond to. If you don't narrow it down, you could get an objection. Okay. If you are served with interrogatories at the same time you receive the petition to modify or the petition to enforce, then you have 60 days to respond. If you receive the interrogatories after service of the petition, then you have 40 days, plus you have 5 days for mailing. So it comes out to 45 days. You must answer under oath. Objections must be for good cause. You need a sign under oath if you're for any objection. So the party who answers the interrogatories must sign them under oath. An attorney who objects to any interrogatories must sign the objections. Service, you're going to serve by mail. So once you answer everything, you'll mail a copy of your answers to the other side. You don't file them with the court. An answer to an interrogatory may be used to the extent allowed by the Arizona Rules of Evidence. So once you receive the answers to the interrogatories, that can be used in court as a trial exhibit as under oath testimony. And then if the answer to an interrogatory may be determined by looking at documents, then you can just point the other side to those documents. You can specify the records to be reviewed and give them a reasonable opportunity to examine and audit the records and make any summaries of them as needed. So that's an option as well if you're getting into long, complex documents. Here's an example of uniform interrogatories. I've tailored these. Here's some instructions. This is standard language. Okay, here's some of the uniform interrogatories. Now you'll need to think about what's at issue in your case. So for example, if the only issue in your case is to modify your parenting plan, then you likely don't need this information about contact information, education and training, or employment. However, if child support modification is at issue, then this employment information could be useful. So really look at this and tailor it to your case and make sure that it's asking for information that's different than what's required under the disclosure of Rule 49. Health insurance, other income, employment benefits, again, tailor this to your case. Here's questions about legal decision-making and parenting time, child protective services, personal limitations that can relate to one of the best interest standards, driving history, employment history, criminal history. Again, as long as this stuff is relevant to your case, domestic violence, tax returns that could be relevant in a divorce, or excuse me, in a child support matter, child support modification, or child support enforcement. If attorney's fees and costs are at issue in your case, witnesses and exhibits, questions about those. And then if you want the other side to produce an affidavit of financial information or any additional information about property they own in relation to a request for attorney's fees and costs, number 26 would be related to that. So again, this document is optional. You don't have to send out uniform interrogatories, but if you do, you need to tailor them to your case before you send them out. For serving the interrogatories, you're going to mail the original and one copy to the opposing party or their attorney, and then they get to mail their response to the interrogatories 45 days after service. If they receive the interrogatories as part of service of the petition, then they'd have 60 days. All right, let's look at the third type of discovery tool. It's called a request for production of documents and things. This is under Rule 62. A party may serve on any other party a request for them to produce and permit the requesting party to inspect, copy, test, or sample items in the responding party's possession, custody, or control. So documents, tangible things, or permit entry onto land to inspect things. So this most commonly is used in a request to produce documents. You can request up to 10 items or distinct categories of items, and you must describe with reasonable particularity each item that you want to inspect or have be produced. You need to specify the time, place, and manner for an inspection if you're asking for an inspection. And you may specify the form or forms in which electronically stored information is to be produced. There's 40 days to respond, plus the 5 days for mailing, or 60 days if the request for production was served with the petition. For each item or distinct category of items, the response must either state that inspection or production will be permitted, or state the grounds for objecting and include the reasons. An objection must state whether any responsive materials are being withheld. And a party objecting to part of a request must specify the objectionable part and permit inspection of other requested materials. These same procedures apply to producing electronically stored information. So take a look at this if that's coming up in your case. And then here's an example of a request for production of documents and things. So here are the list of things to be produced. This is narrowed down to income information. This could be used in, for example, a child support modification case or enforcement case. But again, tailor this to your case. You may not need all this information. So this is requesting records for the past 3 years, and you may only need current income information. So you're not obligated to use this form. Only use it if it's relevant in your case and tailor it to your case. How do you serve a request for production and how do you respond to it? Well, you serve it by mailing the original in one copy to the opposing party or their counsel, and then you would mail or email your response to the other side 45 days after service, or 60 days if it was served with the petition. Nothing is filed with the court. All right, let's look at the fourth type of discovery tool. It's called a request for admissions. This is under Rule 64. A party may serve on any other party a written request to admit, for purposes of the pending action only, the truth of any matters within the scope of Rule 51B relating to facts, law, opinions, genuineness of any described documents. Each request must be separately stated. Unless the parties agree or the court orders otherwise, you're limited to 25 requests for admission. The same timeframes apply, the 40 days plus 5 days for mailing, or 60 days if the request is served with the petition. If a request is not admitted, so a request for admissions is generally getting you to answer yes or no, or true or false. And so if you're answering false or no, so you're not admitting the statement, then you need to specifically deny it or state in detail why you cannot truthfully admit or deny it. A denial must fairly respond to the substance of the request. A party must state their grounds for objecting to a request, and the requesting party may move to determine the sufficiency of a response or objection if they have questions about that. Now, a request for admission is deemed a conclusive admission. So if you admit to something in a request for admissions, then that is deemed admitted for the rest of the case. So keep that in mind, that your responses are under oath and can be used as part of the trial, or it can be used as proof at the trial of a fact that's not in dispute, or law, or some other admission that's critical in the case. To serve a request for admission, you'll mail the original in one copy to the opposing party or their attorney, and then there's 45 days to respond, or 60 days if it was served with the petition. Now let's look at depositions. Depositions start with a notice of deposition. So a party who wants to depose a person must serve written notice to every other party at least 10 days before the date of the deposition. The notice must state the date, time, and place of the deposition, and if known, the deponent's name and address. How can a deposition be recorded? By a certified court reporter, or by recorded audio or audio-visual means. A transcript will be produced by the certified court reporter, and the person requesting the deposition is responsible for the cost of the original transcript. A deposition can be done remotely. There's the rule for a remote deposition. And then a deposition should be of reasonable length, is presumptively limited to 4 hours, and must be completed in a single day. Keep in mind that an unreasonable refusal to extend deposition time may result in sanctions. So if the other side wants to go, 10 minutes beyond the 4 hours, you probably just want to go with that, because there could be a risk of sanctions if you don't. Okay, so let's just to summarize, a deposition is where you have a person come in, usually to a conference room, and testify under oath. You're just not in the courtroom doing it. So this is under oath testimony done outside of a courtroom. And then if a matter does end up proceeding to trial, that under oath deposition testimony can be used at trial. All right, another discovery tool are evaluations. So this is under Rule 63. The court where the action is pending may order a party whose physical or mental condition or ability to work is in controversy to submit to a physical examination, mental or behavioral health examination, or a vocational evaluation. So this happens on motion. And then if the court is going to grant the order, then the order has to include certain things. So the order can only be entered on a motion for good cause shown and on notice to all parties and the person to be examined. It can also be entered if the parties are in agreement, or the court can do its own motion for an examination. The order for the examination must specify the time, place, manner, conditions, and scope of the examination, and must specify the person or persons who will perform the examination. Okay. So if you want to request an evaluation and the other side doesn't agree, you would need to file a motion for examination, and then within the motion, explain why there's good cause for it, and also propose who's going to do the examination, explain what it's going to cost, who's going to pay for it, all of the details about the examination. So if you want to request that your co-parent be evaluated, you'll need to draft and file a motion for evaluation, explaining the type of evaluation you're requesting and why there is good cause for the evaluation. You'll need to draft and file a proposed order for evaluation, specifying the time, place, manner, conditions, and scope of the examination and who will perform the evaluation. And mail a copy of your motion and proposed order to your co-parent or their attorney. Your co-parent or their attorney can file a response to the motion, and you can file a reply to the response. And then the judge can grant or deny the motion, or the judge could set oral argument on the motion, hear the oral argument, and then rule on it. When the parties agree that an examination is appropriate, but don't agree on the examiner, this Rule 63B1 explains the process to go through. So essentially, a party who objects to the examiner may file a motion, and then the court can ultimately make a determination on who should do the examination. Failure to appear. If a party fails to appear for the examination, they could be subject to sanctions. And then a person who is to be examined has the right to have a representative present during the examination, and they can record the examination unless the court orders that it can't be recorded. Also keep in mind that for a mental or behavioral health examination, you can't have a representative and you can't take video. So physical or vocational, you can have a representative, you can record it. Mental or behavioral, no representative, no recording. If there is a recording made, it must be provided to the other party upon request. The examiner will create a report in writing detailing their findings and conclusions, and both parties are entitled to a copy of that report. Okay, time to respond to a discovery request. Just as a reminder, if you're going to get a subpoena, you need to allow at least 14 days for the other side to respond to the subpoena. For interrogatories, there's the 45 days to respond. If the interrogatories were served with a petition, it's 60 days. Request for production, 45 days, 60 days if served with a petition. Request for admissions, 45 days, or 60 days if served with the petition. Do you file anything with the court? For a subpoena, you take the subpoena form to the court will issue the subpoena, and you file a proof of service of the subpoena. Interrogatories are not filed with the court. A request for production is not filed with the court. Requests for admissions are not filed with the court. Okay, all right, we've reached our summary of today's lecture. So just a reminder, there's disclosure, which is pursuant to Rule 49, where each side has an obligation to produce certain documents and share certain information, whereas discovery are legal tools available to obtain answers, information, and documents. There's a subpoena is a discovery tool, interrogatories, request for production, request for admissions, a deposition, or evaluations. All right, thank you so much. I hope that was helpful. And if you have any questions, feel free to bring those to the Q&A.